Welcome, everybody, and thank you so much for joining us today. All right, so before we get started, I always like to introduce myself. If you haven't been on one of our webinars before, or don't know who I am, my name is Adina Glincher, and I am the Senior HR Services Advisor here at PayEntry. As always, we do like to state that this training does not constitute legal advice. We are not attorneys, at least not in this lifetime. So if you have questions regarding legal advice or legal counseling, please do reach out to your attorney directly. And then for any questions at all about the content of the training today or any HR questions that may cross your mind, please feel free to reach out to us at hrservices@payentry.com. And we will do our best to make time for a Q&A session at the end of our presentation today as well. So if time permits, you can always ask questions at that point. All right, so why are we here today? Today, we're going to be discussing investigating complaints. And I think my colleagues would all agree with me that this is one of the #1 questions we get as HR consultants is, I have this issue, can you help me figure out how to go about investigating this? So on our agenda, we're going to be discussing the importance of an investigation, steps to a successful workplace investigation. We're going to talk about when an investigation is actually required, beginning the investigation, planning the investigation, conducting interviews, evaluating the evidence involved, and that may differ depending on the situation, taking action, documentation, following up is always important, and then of course we will end with our Q&A. So why do we even care about this topic? Why is an investigation important? First and foremost, an investigation often prevents and promptly corrects harassment. If harassment is going on in your workplace and you completely ignore it, it's likely to continue to go on. But if you investigate it and you put an end to it and potentially distribute some disciplinary action, it's likely to halt any harassment. Good investigations save you money, avoid damage to your company image, they promote a positive work environment, and then successful lawsuits breed more lawsuits. So what do we mean by this? When an employee sues their company, or a company, I should say, if they win, other employees are going to be more likely to sue because they see that the result may be positive for them. So it's important that you are investigating any issues in your workplace and you're doing so diligently. And then we did include a quote from the EEOC. If the employer has an adequate policy and complaint procedure, but an official failed to carry out his or her responsibility to conduct an effective investigation of a harassment complaint, the employer has not discharged its duty to exercise reasonable care. So oftentimes you are legally required to engage in an investigation. Next, we're going to review the steps to a successful workplace investigation. First and foremost, do we need to investigate? Make that decision. Secondly, take immediate action if necessary. 3, choose an investigator. 4, plan your investigation. 5, conduct interviews. 6, evaluate the evidence. 7, take action. 8, document the investigation, as we like to say in HR. If you didn't document it, it didn't happen. And 9, follow up. And we're going to dig into each of these as we go through the presentation. So when is an investigation required? So we have an example for you here. Sarah and Ben were outside taking a break when Ben asked Sarah on a date. Sarah felt uncomfortable and told Ben no. Ben let the situation drop, but now Sarah has spoken to HR. Ben admits to asking Sarah on a date when the subject is brought up. Is a workplace investigation necessary? So take a minute, think to yourself, yes or no? In this situation, the answer would be no. The situation would not require further investigation as everyone agrees with the facts of what happened. This would likely not be considered sexual harassment, and Ben did not pursue Sarah any further. Now, of course, as we all know through our harassment prevention training, that if Ben continued to ask Sarah out on a date, then that may have led to what we call sexual harassment, which definitely would have involved an investigation. But in this case, the facts are pretty cut and dry. Another example for you all. It's Friday. A group of employees are congregating after work on the premises. Two of the employees begin showing off their boxing skills when one employee's aim comes too close and harms the other employee. This results in an altercation. Monday comes around and the supervisor hears employees talking about that employee being beaten up. The supervisor sees this as good humor and advises them to drop it already. Is a workplace investigation necessary? Go ahead and type in the question box. Let me know. Do you think so? Yes or no? All right. I am getting a mixture of answers, so I'm glad you're all here today. In this case, yes. Workplace violence goes against most company policies, and there are many factors at play. I want to know who was involved in this boxing incident. Were there witnesses? What started it? Why did they feel it was appropriate? Was there some comment made that made the employee become violent? I have so many questions, and in a case like this, the facts are not as specific. We definitely need to investigate. Next, assess the situation. An investigation may be required when an internal complaint or incident occurs, a government agency complaint or inquiry occurs, a civil lawsuit or criminal complaint occurs, an accident or injury happens, or an employer or manager learns about harassing, threatening, intimidating, violent, or other inappropriate or illegal behavior. So these are all instances when you actually may be legally required to conduct an investigation. All right, another example. What if you become aware of misconduct even if no one has complaint? A, employers have a duty to take prompt action once they have knowledge of employee misconduct. B, ignore it and hope it goes away. Or C, there is no obligation to investigate since an employee has not filed a complaint or lawsuit. Let me know your thoughts. Go ahead and type them into the question box. All right, I'm seeing a lot of right answers. Good. The answer is A. Thank you for your participation. Federal and state laws require employers to investigate allegations of certain types of employee misconduct. This obligation exists regardless. Make sure employees feel comfortable raising issues concerning misconduct. All right, one more example for you. What happens if you learn of misconduct well after the fact, months or even a year later? A, should you dismiss the complaint as it reached the statute of limitations? B, delayed complaints are just as important as any other complaint. Or C, do nothing. All evidence is either lost or no longer available. Oh, you're all already submitting your answers. Great job. And you are correct. B, regardless of legal liability, misconduct can poison the working environment. It is possible that a complaining employee can go to a government agency or sue in court. You can never be too sure. So once you hear about it, it's important to start investigating. And sometimes it takes employees some time to be comfortable even going to somebody and talking about what had happened. So this is a fun acronym we like to use. And when you are involved in an investigation, it's important to respond like a leader. First, listen. Create an atmosphere in which employees feel comfortable raising their concerns by taking every report seriously. Encourage. Thank the employee for coming forward and reassure the employee that no retaliation will take place. Ask questions. Get answers. Who, when, where, how, and why, right? Those are our most important questions. Document. Immediately create a written record of the employee's statement, or you can even ask the employee to submit a written record and ask the employee to review and sign your documentation if you're the one taking notes. Explain. Explain relevant policies and answer any questions the employee may have. And lastly, respond. Report the conversation to the designated individual to initiate the investigation and/or take the necessary steps to do so. I know as leaders in our organizations, we all have a lot going on, and sometimes it is not convenient when an employee comes up to us and says, hey, I really need to talk to you about something. But it's important that we're prioritizing those one-off conversations because sometimes they rise to the level of a complaint that needs to be investigated or just a complaint that the employee really needs to feel heard out. Confidentiality. So I really love talking about this topic because I think confidentiality when it comes to investigations is often misconstrued. An employee may ask their complaint to be kept confidential, because they wish to handle the matter on their own, they don't want the situation to become public, or they don't want to be regarded as a problem employee, or because they fear retaliation and don't want to be responsible for getting anyone in trouble. You cannot promise complete confidentiality when an employee comes to you. And I know that that's hard to hear. Generally, in your organization, you have to report complaints to HR or whichever designated individual is supposed to be the one to hear the complaint. Even if a person who reports misconduct asks that no action be taken, an employer that does nothing in response can be held liable for the misconduct. And if a decision is made to honor a confidentiality request because the alleged misconduct is not severe, ongoing, or adversely affecting others, make sure you still document the request. So if you are a manager or a business owner, and employees often come to you to express their concerns regarding other employees or certain situations in the workplace, it is important that before that employee goes on and on about what's going on, you do let them know. You cannot keep what they're going to tell you completely confidential, but you can make sure that only the parties who need to be involved will be involved. You're not going to announce it to the entire organization. You're just going to let people who need to know. Formal or informal investigations. So make sure that you carefully analyze the facts. Is the situation disciplinary, or are you dealing with something else? Maybe it's a training gap, maybe there's just a misunderstanding. Generally, informal investigations come from misunderstandings over policies, standards, and work rules. Consultation with HR or a designated individual to clarify any misunderstandings, usually a one-time meeting or a one-time conversation, fixes the problem. A formal investigation is generally done when a situation involves more than one employee. It happens when there is a pattern of unacceptable behavior or the conduct is very severe. Documents or other evidence needs to be examined, and other evidence can include meeting with witnesses and hearing their statements. And special expertise is needed to reach a conclusion. So beginning the investigation, be prompt. This is very important. Take prompt action when inappropriate workplace conduct is found. Let's say you have an employee who feels they are being harassed at work, and what's today? Today's Thursday. They come up to you and they say, I feel like I'm being harassed. You meet with them and you don't begin your investigation for 3 weeks. That is not going to make the employee feel good. And who knows what is going to continue to happen in those 3 weeks. So although you have a ton on your plate, it's important that the employee feels you are listening and that you are taking their complaint seriously and you are addressing it immediately or as soon as you speak to your attorney or your HR professional for advice. Legal liability is limited if the investigation is quick, thorough, and fair. Prompt action sends a clear message. Inappropriate conduct and policy violations will not be tolerated. An immediate response to a complaint does not, however, translate to a quick, superficial investigation. Take the time needed to make the investigation thorough and complete. Of course, make sure you get your resources needed to have a great investigation. Make sure you speak to any professionals who are assisting you through the process, but definitely prioritize it. In addition, clearly designate who in your organization will handle complaints. So more than likely, this should be 1 or 2 people, and it should stay the same 1 or 2 people, regardless of which department it's happening in or who it involves, unless, of course, the complaint is against one of the people who are generally designated as that person. The direct manager should not be the designated individual. The investigator should not be in any way associated with the complaint. We want an outside party. And maybe that's just HR, maybe that's a completely outside source, which we'll get into. Most investigations require someone with specialized knowledge, and often the investigator will be a member of HR, an EEO officer, a trained individual outside the company, and investigators may partner with an in-house attorney. Unfortunately, as HR advisors or HR consultants, we are not able to lead investigations for our clients, but we are absolutely here to walk you through the best practices, answer any questions you may have, and even role play with you to make sure you're comfortable leading an investigation within your organization. Plan the investigation. Be consistent. Understand the nature of the complaint. Gather the facts about what happened. People like to ramble on, especially when they're in a maybe disgruntled state. So make sure that you are focusing in on the exact complaint and the details surrounding that. Who will you need to talk to? What evidence will you need to collect? Maybe you have camera footage to review. Maybe you're looking at time cards or some type of text messages or some type of statement. What policies are involved? Do you have copies of those policies in front of you to review? What records or reports will you need? What investigational tools will you use? And what is your time frame for completing the initial interviews? Setting a time frame will help you stay on track and prioritize. The do's and don'ts. So for conducting interviews, make sure you remember that participation is voluntary. You can't force an employee to meet with you. Watch for leading questions. Use open-ended and specific questions both. So if you want to know exactly what time something happened or exactly what was said, ask those details, but also ask some open-ended questions so you can gather additional information. Make sure you do this in a private place and observe the employee's body language, but of course don't overanalyze it. People are often nervous or, disgruntled when they're having these conversations. Some things to avoid. Do not reveal what you already know. If an employee comes up to you and, or if you ask an employee to meet and they're a witness to a harassment case, don't let them know all the details. Hear it from them directly, as details may change depending on who you're speaking to. Don't agree with the person just to appear empathetic. So this is something that happens very often. And an example of this would be if you're meeting with Susie Q, and Susie Q says that she spoke to Bob, and Bob, was being his usual annoying self and talking about women inappropriately, and you go, oh yeah, I absolutely know what you mean. Or, oh yeah, that's just Bob for you. Then you are agreeing with that employee, and more than likely so that you appear empathetic, but then you're putting all of this assumption on Bob. So make sure that you listen, that you nod, and you really take notes and allow the employee to speak. Don't play judge, always treat the accused as innocent. Stick to the scope of the investigation, and don't forget privacy and confidentiality, to the extent possible, of course. When you're conducting interviews, you will need to interview all relevant individuals. So start with the employee who complained, next, if relevant, the person being accused, and then finally interview all other witnesses. For each person, review the scope of the investigation, let them know why you're meeting with them without giving away too much information. Ask for leads. Was there anyone else present? Have you noticed this behavior before? Prepare the questions before the interview. Of course, we want to be prepared. Provide an opportunity for that employee to give input, or maybe you end the interview by asking if there's anything else that they want to share. Take notes and have the individual sign off on the notes you have taken. So what if you have an employee who refuses to be interviewed? Well, unfortunately, this happens often. If it's the accused who refuses to be interviewed, let them know that you want to hear both sides of the story. Let them know why you want to meet with them, and make it clear that if they refuse, you will complete your investigation without their input. You still may be able to discipline the employee, but that will not help your investigation. So do your best to, ask them to meet with you and explain the importance of meeting with them. When the alleged victim refuses to be interviewed, which generally doesn't occur unless it's a harassment case and somebody is reporting to HR or to their manager that they witnessed somebody else being harassed, and that person does not really want to do anything about it or doesn't want to get anyone in trouble. Make sure that you continue the investigation with the information you are able to gather, and you still may be able to stop someone's harassing or discriminatory practices, even if the alleged victim refuses to meet with you. So continue the investigation. Evaluate the evidence. Review the documentation. Make sure your documentation is complete. Determine if there are any conflicting statements. there's, what is it, 3 sides to every story, right? So generally, you're not going to hear the exact same story from everybody. Remove anything that's not relevant. Determine the credibility of the witnesses. So is it a he said, she said situation? Was it one of your managers who have worked for you for a long time who witnessed this? Or maybe was it a brand new employee who hasn't worked for you for very long? Make sure you weigh the facts, arrive at a fair, objective, and defensible conclusion. Either the allegations have been proven or they have not. Take action. After you have reached your conclusion and written your investigative report, you must make your final recommendation. So make sure that if you are choosing to discipline somebody, you're choosing the proper discipline, that you're being consistent. Make sure you're prepared before engaging in these conversations. Understand the different options regarding disciplinary action or corrective action. Of course, no action, an apology, training, warning, probation, suspension, dismissal are all options. As mentioned, be consistent. So if you had a similar situation happen in the past and all you required was that an apology was given, then it would be probably inappropriate to dismiss the employee this time around unless the facts have definitely changed, and take prompt action as we discussed. All right, true or false? And I'm going to ask you to put your answer into the question box. An employer should discipline an employee who files a false complaint. This might be a tricky one for some of you. All right, I'm getting a lot of trues. Some falses, so a good mix. All right, false. Generally, it was kind of a trick question. Avoid imposing discipline on the complaint party unless absolutely certain that that person was fully aware of the claim being false at the time they made it. And it's almost nearly impossible to do this. Discipline of someone who mistakenly reported perceived misconduct can discourage employees from making complaints and result in being sued for retaliation. Ooh, and I see someone said false due to retaliation. Great answer. How do we prevent retaliation? So encourage the person who reported the conduct as well as employees who participate in the investigation to let HR or a member of management know immediately if the reported behavior continues or if there are any further problems. Continuing to monitor the situation in order to ensure that the alleged perpetrator does not engage in retaliatory or other inappropriate conduct. Make sure you immediately stop any conduct that appears to be retaliation. Counseling employees suspected or accused of retaliation about what retaliation is and the consequences for engaging in such action. And after stopping retaliation, following up to ensure it does not resume. And whenever you finish an investigation, it is always important to follow up with all parties and to let them know to make you aware if any retaliation occurs or if they have any other concerns. Make sure you document the investigation, because if you didn't document it, it didn't happen, right? So what do I need to document? Always document all your investigative activities, noting the date you met with people, the time, the place, your remarks about the incident. Include the who, what, where, when, why, and how. The reason this investigation even occurred, witness statements, course of the investigation, investigative findings, the action taken as a result, and your action plan for following up. And following up. Follow-up is necessary to make sure that the misconduct has stopped and that no retaliation has occurred, as we just spoke about. Periodically follow up to ensure that the misconduct has not reoccurred. So maybe you follow up with the person who submitted the initial complaint, a few weeks later to see how things are going, and then again a few months later to make sure things are still going well. Check in with the supervisor / manager to see if there have been additional problems. Failure to follow up can result in legal liability if the misconduct continues. So you want to make sure you're doing your due diligence. So we are here to help. So our HR professionals can help you. We can help you update and create employee handbooks and company policies. We can help you review investigation best practices. We have a ton of resources for our clients on how to go about engaging in an investigation and the best practices. We can help provide documentation and resources, keep up with changing state and federal laws, and assist with day-to-day HR best practices, forms, policies, and more. And then our HR services compliance package also includes a learning management system with a broad array of employee and manager trainings, including state compliant harassment prevention training. I see there's some questions coming in. I'm absolutely going to get to those. Before I do so, if you need to log off for time, please remember next week, our webinar will be on Tuesday. So we're changing it up, in 2 weeks, bi-weekly. So in 2 weeks, our webinar will be on Tuesday at the same time, 2 p.m. Eastern, 11 a.m. Pacific. We need to change it for some scheduling issues, so please make sure to join us for that one. And it will be on the importance of harassment prevention training and who it may be required for. All right, now we're going to get into the Q&A. Great question. How long do you keep investigation documents? So this may depend on the state that you're in. So I am going to take this back and I will actually email you the answer directly because I want to dig into it, make sure I'm giving you the right answer and want some additional information from you to figure out what state you're in. So great question. Should we keep other employees involved names anonymous, the employee doing the accusing or that witness's situation? That is also a really great question, and that is generally going to depend on the investigation. So my general recommendation is if you can avoid saying the employee's name, avoid saying the employee's name. More than likely, when you are meeting with these individuals, based on the details they're giving you or the questions you're asking, they're going to have an idea of who you're referring to. But it is important that you aren't saying, hey, so-and-so came up to me and complained, and we want to know your side of the story. So yes, keep the name anonymous as much as you can. But if it comes up, just don't confirm or deny, just continue to ask your question. And if you, the person who asked that, if you have a specific question regarding a specific situation, reach out to our team and we're happy to help. Will we receive a link for the next training on sexual harassment? So the next harassment prevention training, the one in 2 weeks is actually on, it's not a sexual harassment training itself, it's on the importance of it and which states require it. We do not offer free harassment prevention trainings here at Payentry. If you are a payroll client or an HR services client and you want to learn more about the different offerings, definitely message us at hrservices@payentry.com. I just put it up on the screen and we can kind of talk you through your different options. Some are live webinars and then some are e-learning options. All right. Can these slides be emailed to me? So the recording will be emailed to you and there's actually a handout that you can download. If you go to the handout sections on the right side of the screen, you can download those, the slides from today. Is verbal abuse caused for an investigation? Yes, absolutely. Verbal abuse or verbal harassment is absolutely a reason to investigate, and there may be witnesses associated, or maybe you can just meet with the two parties involved and determine what happened. So yes, absolutely. Okay, let's see. Any last minute questions? You guys asked some really amazing ones today. Thank you for your participation. All right, I think we've covered them all. If anything comes up, please don't hesitate to email us. Otherwise, we hope you have a wonderful rest of your day and we hope to see you in 2 weeks on Tuesday. Thank you, everybody.